The next case on the docket is NOAA versus Florida Insurance Guarantee Association. Whenever you're ready, you may proceed. Take your time. Sometime today will be good.
May it please the Court, Paul Feldman on behalf of NOAA, Mr. NOAA, and I have with me Leo De Silva, my business partner, and Mr. Benjamin Alvarez also, who is here. We're here on the issue of whether or not my client has a right to have an appraisal of his ordinance and law, and the decision of the 3rd District Court of Appeal, which I think conflicts with not only Joseph Folk out of the 4th District, but this court's decision in Sabalo, said that the ordinance and law is baked into the initial appraisal, which runs counter to the law of the state of Florida, which says that ordinance and law cannot be appraised because it needs to be incurred first. In Sabalo, we had a total loss of a home, and in that case, even in a total loss, you could not get ordinance and law because it was necessary for them to incur it, to be liable for it. So in this case, there was an initial appraisal of the property, and on the face of the appraisal award, it said ordinance and law not appraised, exactly the same as Joseph Folk.
Well, but that, as I understand it, and this case troubles me because there are a lot of holes in both sides, it seems. In this case, there's only 3% of the roof damaged. Am I correct?
No, you're not, Your Honor, and respectfully...
Okay, well, correct me, because that's the way I'm reading this.
Okay, that's respectfully, if I can clear that up for the court, because I think that's something that really became determinative in this matter, and it shouldn't have been. This 3% came from a letter from the insolvent First Home Insurance Company's in-house examiner who reviewed the file in Maitland, Florida. So
this was not part of the appraisal?
The award says not appraised. It does not say $0 for ordinance and law. It does not say 3%. What the examiner...
Is the math wrong? Because...
Yes, it is, and I'll tell you why.
It's 120 tiles.
Correct.
What percentage is that of the number of tiles that were there?
Let me explain it, because
I understand what your explanation is going to be, but that math is correct. If you take 120 tiles, is the amount that the...
Yes, that math is correct, but it's incorrect as it relates to construction and how you repair a roof, which is really what was ignored here.
I'm looking at the affidavit that was... we have affidavits below from the insurance company's appraiser and from your client's appraiser, correct?
Correct, and from the roofer who actually talked, the licensed roofer.
Attached to the affidavit from the insurance company's appraiser is the, what he says in the affidavit is that the award of $17,602 is an award that's based on the umpire's assessment of the repairs that were needed, correct?
That's what he says.
And it actually attaches to the affidavit the umpire's assessment that predated the appraisal date, correct?
I think that was his, you're talking about his own, the Gale Claims Service?
Yeah, Gale was the umpire, right?
No, that would be, I think Mr. Gale was the, he was the umpire.
Yeah, he was the umpire. So he was the third one, and the attachment to the affidavit is, comes out to the same amount, $17,602.10. That's the exact amount that was awarded, correct?
Correct.
And it's in there that he is describing. Now, a lot of that was for building damage, but the roof damage part of that, he says, repair and replace 120 tiles. That's what the umpire's assessment of what had to be done, that's what he priced out, correct?
Actually, no, Your Honor. What was left open was ordinance and law, and let me explain to you why. If you look at
it is a factual matter. That is what he priced out, you didn't dispute it in a counter affidavit that he priced out replacing 120 tiles.
No, we did. Our roofer put forth that the methodology of replacing 120 tiles spread over the roof was to replace the one tile and the 8 around it. But I want you to take a look at
He
Mr.
said that's how we normally do it, but did the insurance contract require the insurance company to pay for how you normally do it? Or did it require them to pay the least cost way to effectuate a repair to the damaged area?
Well, he's a licensed contractor, so he has to do what's required under the law, or he has to face the DBPR, or he has to possibly be sued. But I would like you to take a look at Mr. Gale's, because it was left open, Mr. Gale's assessment. If you take a look at the underlayment, which is the plywood that you put under the repair, there's 1,200 feet of underlayment. Why would you, if it was 120 feet, why would you have 1,200 feet of underlayment of plywood? That's why this really does turn on an understanding of construction and what needs to be done. And the only evidence that was put in below on that was from the roofer who did the work and had to get the approval of Miami-Dade County. And he put it in for a repair, and he put it in for the lesser amount in order to try and do that. And that was less than the money that was
Was the amount of the
awarded.
underroofing part of the initial appraisal?
Was the amount of what?
Was the amount of the under plywood coating part of the initial appraisal?
Yes, it was. So, but the issue then is if you leave the ordinance and law open, what they're looking at is, okay, we have to do the repair, and the repair is going to require, well, we have 1,200 feet of underlayment. It's not going to just be 120 tiles, these one, set of tiles. They're spread over the roof and they need to be repaired, and it was left open. It said ordinance and law not repaired. It's exactly what went on in the case of Jost Folk. And what the third district said was the issue of the ordinance and law is baked into the appraisal, that the umpire must know what the building codes are. The umpires aren't licensed. They can be judges, they could be retired attorneys, they could be anyone who's designated to be an umpire. So, and that issue of saying that the ordinance and law is baked into the appraisal, the initial one, would mean that you don't get your additional coverages. These coverages do not come into effect until they are incurred. This would mean additional living expenses also.
Let me ask you another question. I noticed in the permit application that said that the builder put in for replacement of 30% of the roof. That was what he put in.
Correct.
Replacement of 30% of the roof. It also put in replacement of rotten wood. And was that part of the covered damage?
I would presume it has to be, because they have to replace the wood that's damaged when they do the roof.
But I mean,
that's the underlayment. That's the underlayment. So to get to the rotten wood, you have to remove the tiles.
The insurance company is responsible for damage caused by a covered peril. And I'm having a hard time understanding how rotten wood would be caused by a covered peril.
Well, once the damage occurs, in order to do the repair under the building code, they have to repair any rotten wood that they find. If you have your roof replaced, that's what happens. They have to take that out. So that's why this 1,200 square feet of the underlayment reveals that there was a large area, as attested to by the roofer, much more than just saying, oh, 120 over, approximately 4,000 feet, that's all we're going to have. That's not the way it goes. They have to get to the rotten wood, take all that out. Otherwise, it's not going to pass an inspection with the building department. I mean, that's just a fact of the matter. They're going to go out and inspect it. If they see there's rotten wood there, they're going to ask them why that wasn't taken out. That has to be part of the repair.
But whose responsibility is it, I guess, is the question.
The carrier. I mean, it's not, my client doesn't get to ordinance and law to deal with the additional tiles that need to be taken out until it's incurred. And that's
so if when they go to do the work, they discovered that there's termite damage. I mean, the building code would require that be replaced, right? Is the insurance company responsible to repair the termite damage just because it has to be repaired now that it's discovered because there was a covered peril affecting a roof tile?
Well, under, what's the third DC case, Gold? It would, unless there's anti-concurrent causation language, then, you know, that would, if that was not covered, it would be something that would flow from a covered peril under an all-risk policy. So we're going beyond what I'm not going to be able to read whether there's anti-concurrent language.
Okay.
If there is not anti-concurrent language, yes, they would be responsible for it because the covered peril is something that's covered. And so what comes from that would allow for the non-covered plus peril. Plus the issue of the rotten wood, this was storm damage. And so you have tiles that have been lifted, and now you've got wood underneath that's been infiltrated by water, and we have 1,200 feet of it.
Can I go back to just the basic issue, which is that you take the question of how much of the roof was damaged seems like a big difference between 3% and 30%. You agree with that?
Yes, I do.
And at the time, the appraisal was, you had the opportunity to present your evidence of what the damage was, to get as many estimates as you wanted. And so I'm having trouble to understand, and I think whether this was in the language of the opinion, that you can find a contractor to say we're going to repair more of the roof, and then we're going to get a whole new roof, which is a pretty big, to go from 3% to I'm getting a whole free roof, it seems extreme. So why shouldn't you be bound by the initial appraisal? I mean, we're not talking about, well, they thought it was 28% and then it went to 32%. There's a real question of the credibility of the second estimate.
The credibility, Your Honor, is in relying upon a letter, undated, from a now bankrupt insurer who, when ordinance and law, before the work was done, he said, this is what it's going to take to fix my roof now. I went to go get a permit.
What is the appraisal process that you went through initially? You're telling that it was all based on just some letter and there wasn't an umpire?
No, there was an umpire.
There was?
And there were, yes. There were
did you have did your client have an opportunity to present whatever evidence needed to be presented about their estimate?
Yes, just as in Joe's Folk, the umpire was presented with, they're going to need a roof, and the insurer's appraiser saying, no, they don't. He attributed some damage to the roof and left the issue of ordinance and law open.
Well, now that's the big question.
Which is exactly what happened here.
You're saying, okay, so the question though is, if it had been appraised at 30% and they didn't allow for the ordinance, you'd have a second issue. But when it comes in so much below what would trigger the entire roof being repaired, I'm just having a hard time understanding what would entitle you to a second appraisal.
The issue is that the 3% is this fuzzy math that was done to reject the ordinance and law claim when First Home got the claim back. It's not 3%. The only testimony below was from the roofer as to how the work needed to be done, and he tried to go in and do it as a
Is the problem that there's a factual dispute about the extent of the repair that was determined as necessary by the umpire, who split the difference between, I mean, who didn't? I mean, he sided with the insurance.
Well, I don't know if he did, but I know what they're getting the 3% from, but that's not even an affirmative defense. The issue is the methodology, I think, would be the issue, if there's factual issue, as to how you're supposed to repair this roof. If you have 120 tiles over the whole roof, and they're saying you're going to have to put in 1,200 feet of underlayment, you're going to have to take up more than 120 tiles, and that's why you
But not 30%, if my...
Well, it would be, because it's if you look at the math, which is in the brief, and the methodology is, it's 1,100 square feet if you take out what the proper methodology is.
I mean, part of the problem is this is bizarre procedurally that we're here on an appeal from an interlocutory order I mean, because both sides moved for summary judgment if
No, we didn't. We moved for appraisal. The other side moved for summary judgment, and actually, the third district actually kind of granted them summary judgment on the appeal.
but I mean, you were sort of asking for summary judgment by moving for,
And they also moved to reopen the appraisal. So they wanted an appraisal too. They just wanted to reopen the original one.
well, no, but I think that what they asked for was, well, okay, go back to the original appraisers, and if there's a question as to what the appraisal process determined, then let those appraisers tell the court, the trial court.
But the case law that we cited doesn't allow that to happen, which is
But why don't we
why
just,
why we
why
sought the
wouldn't
second
we,
appraisal.
since there's a factual dispute, or if there is a factual dispute, why wouldn't you let this lawsuit play out? I mean, why wouldn't you just let there be a determination of whether the appraisal, what the appraisal did determine?
I would agree with you that it does need to play out. However,
I mean, you would also agree that if the appraisers determined that 3% of the roof needed to be replaced, if that was what they determined, that you're bound by that and you don't get ordinance and law coverage.
it doesn't say 3% on the appraisal.
I know, but if it did, if that's what
If it said, okay, there's only 3%, that would be binding. It doesn't say 3%.
Right, but, okay, but they say it says 3%, you say it doesn't say 3%. So if it does say 3%, if it did say 3%, you'd realize that you agree that you wouldn't be entitled to ordinance and law coverage,
If it
right?
said 3% ordinance and law, you know, it wouldn't, if they said 3%, I wouldn't be here.
Well,
But it
the
didn't say
percentage
3%.
becomes an issue only because of the ordinance and law coverage, correct?
Excuse me, the what?
The percentage
Yes.
becomes an issue only because of the ordinance and law coverage.
Correct.
Okay, so without that, you've got just an appraisal of what the damage is. Now, here's what my concern is, and I'll say straight up to both of you, is that I'm concerned that this kind of case would lead to circumstances where undiscovered damage, legitimate undiscovered damage, could somehow be not compensated once you get in and start doing your repairs.
I agree with you, Your Honor.
So I think that's a problem.
It is a problem.
However, I mean, but then it comes down to, why was that, I mean, this is not part of, it seems as though it's been treated that this is a fixed amount of damage, and the rest of it's not related to the storm.
No,
So it's not that.
Because it says ordinance and law has not been appraised, and it's been left open, and you have a very clear situation where you have 1,200 feet of plywood, which they recognize will have to go in there. That's a methodology issue, and the only evidence that was brought in below is through our roofer. But there is a concern that there may be additional damages that will be seen once that repair starts to happen. And it says, okay, guess what? Now ordinance and law is going to apply. I get to go back and appraise my ordinance and law. That is a fact.
Well, I mean, it makes sense, is that a tree falls on a roof, and you break some tile, and superficially, it looks as though we've got just a couple of 100 feet of tile. But once they start removing the tile and the tar paper, they say, oh my God, there's a crack right down the middle of the roof boards. That's a different story than rotten roofs and stuff, but clearly related to the tree that's fallen on it. Now, that to me makes no sense that insured could not present that to the insurance company.
I agree.
But here it seems this has been presented in a different context. This is presented in the context of, this is not something that has changed from when the original appraisal was done, but the 3% has crept into it because, and I think it has through some of the affidavits.
Well,
So it may be that there's a factual dispute that needs to go back.
the initial 3% came from the now defunct insurer first.
Well, that may have initially come from there, but somebody else has placed it in exhibits to
But
affidavits.
that's
Am
post-appraisal.
I correct that what your client's appraiser submitted to the umpire was a claim that we need to replace the entire roof, not because we have to replace 30%, but because those 120 tiles that are broken can't be matched and you have to color match.
Well, it's correct that the matching tile statute requires that the tiles match. In this case, the tiles are no longer manufactured. which was the same thing as in Josfolk, which would be a separate and independent reason. The third district said they're going to get new tiles. They're not going to get new tiles. They don't have the tiles. They don't make them anymore. So they're going to, I don't know what they were going to, in their mind they thought they were going to put on there, but those tiles didn't even exist anymore, which was a separate and independent.
Well, I mean,
reason.
the tiles
Hang on,
exist, just
hang on.
not in the same color, right?
Down to 15 seconds in your rebuttal time. I'm going to give you two minutes for rebuttal. Okay, so let's just.
I reserved 5.
Okay.
Did they not say?
If you want to reserve.
Okay, thank you.
Okay, 20 minutes.
Good morning, Hinda Klein here on behalf of FIGA. I agree that one of the problems in this case, and I don't believe it's our problem, is that there are certain things that could have been in this record, but which are not.
Well, let's start with where the 3% came from, because, you know, sitting here listening to this argument has confused me about where we are and what is it that is really at issue here. If it was a 3%, it didn't kick in the law and ordinance, correct?
Correct.
If it was 30%, it would.
Correct.
Okay, so where did the 3% come and what was it based on?
It was purely mathematical, based on the number of tiles that would have to be replaced according to the appraisal award. I think it was
So the roof
120.
was 3,000 some odd square feet. 120 tiles was 3% of that. Is that
Correct.
what that is?
It's, yes, I think it was 3960 square feet, yeah, and I think 120 was 3%, correct. That's where that number came from. And there was 1,100 square feet, I believe, of underlayment in the original appraisal award.
How much did you say?
I think 1,100 square feet.
Well, I'm looking at this Gale Claim Service, Inc., and the roofing repair underlayment, it says 1.00 each, I guess, 1,200.
I apologize, I'm looking, I misread it, yes.
'Cause
1,200.
that's what you're relying on, which was referred to earlier, is this Gale Claim Services
Yes.
attachment to the affidavit.
Right. I was thinking of the unit costs as opposed to the quantity. Right, so,
Well, what's that 1,200 about?
It says unit cost.
yes. And that unit cost was, so it's, I guess it says 1 each, 1.00 each at a unit cost of 1,200. I don't claim to be a roofing expert, but I did just want to point out that that there was an award for underlayment of $1,200. In fact, the total award for the roofing damage altogether was $9,800. It wasn't insignificant. It wasn't just a tiny percent of what a new roof would cost. It was a significant amount.
But that's not 12, is that 1,200 feet or something different? Or is there any way we can tell?
I have no idea. That's all that it says. The problem is when you have an appraisal, you don't have a record of what occurred during the appraisal. So we can only determine.
We have no record of what evidence was presented to the appraisers?
Correct. That's how the appraisal process worked. But they did have an opportunity during this litigation to have maybe filled in some of the missing information. And I would submit that their failure to do so is telling as to the actual scope of this appraisal. Mr. Pyle, who was and is their appraiser as well as their PA, all he says in his affidavit is that I disagree with the appraisal. He doesn't say, I submitted this information, my estimate to the appraisers, here's my estimate. They said we're not going there because ordinance and law is premature at this point. He doesn't say anything like that.
So we don't have any idea of, at the appraisal stage, what, if anything, they said about replacing adjacent tiles. We know there was 120 damaged tiles, but do we have evidence about what needed to be done about adjacent tiles and other things, and the under, I'm sure there's something the tiles are sitting on. I have no idea about roofs except when I need one, I call somebody. But, so, do we have that kind of record before us?
No, we don't. And I submit that if, in fact, this never came up during the appraisal, there would have been one. There would have been some kind of affidavit from Mr. Pyle, who did submit an affidavit, saying that I brought this up, I objected, here's my estimate, you can see from my estimate, I didn't put anything in there.
I mean, the appraiser who was actually there on behalf of your client submitted an affidavit in support of summary judgment that says the total amount of roof tile and underlayment repair awarded in the appraisal award amounted to less than 3% of the total roof area. I mean, so we do have, I mean, that's what, he was the appraiser.
He was our appraiser.
He was your appraiser, and then he
Right.
attaches the umpires. And Mr. Pyle didn't dispute that in the attached affidavit, did he? He came back and said, but we have new information. And based on this new information, the builders concluded that we have to replace 30% now.
Yeah, the way I read Mr. Pyle's affidavit is not that it's new information per se, but that he's relying on the fact that only after the appraisal did the roofer go out and seek a permit for 30% repair of the roof. There's nothing in this record that talks about new information, that talks about that there was an agreement not to address ordinance and law because it was premature.
What about the damage that he, your opponent alleges was rotten and all that? Was there any evidence that this was also related to the covered event, or is this something that was going on already and had nothing to do with the actual hurricane?
Again, we have no evidence because that would have been something, I assume, that came up during the appraisal.
It seems to me that something for me is significant, because you look at somebody getting ravaged by a hurricane. There was Hurricane Wilma in October of 2005, and Mr. Noah first submitted a claim in December of 2005. Over 3 years later is when he submits the claim for under the policy with the sworn statement of $71,000. Factually, and we don't have a record, but it's not as if there was something rushed immediately after the hurricane. I better find a roofing contractor because you couldn't find one back then. And so there's 3 years or 4 years plus of whatever happened in between that time to have to look and say, well, is this now, was the delay in the repair that caused this additional damage? So it's going back to this, the question I guess that we go to is that at what point is ordinance and law coverage come into effect in a second appraisal? Is there ever a situation where that should occur, where it was not contemplated in the original appraisal? Because again, it goes back to what Justice Lewis is saying, fairness about when something is discovered, but where does the delay part come in, which is, to me, is another significant factor against Mr. Noah, that the time, he had a lot of time to look at this and submit his claim before the first appraisal. So it's a somewhat friendly question, but also with the concern that the insurance company could, that there are things that happen when a roof starts to be, the tiles get taken off that might not have first appeared as damage.
There's no question about that, and there is a process by which you can go back to the insurance company on a supplemental claim. Supplemental claims happen every day, and the court made a very important point, and that is that there was a 3-year delay between the first claim, which was actually less than the deductible, and that was back in 2005, and this supplemental claim, if you will.
Well, almost 4 years, actually. It's been a really long time.
Right, and all we know from the record really is that there was a leak and there was some rotting, and it could have been completely unrelated. And
Well, isn't that, I mean, this case seems to become overly complex.
I agree. I
It
agree.
seems to me that if the homeowner and these lawyers felt there was a claim to be made, they would have filed that, which they did in this case. They must have said something about the roof and about the appraisal, correct?
Correct.
What'd they say?
They did a proof of loss. They asked
I'm
for.
sorry?
They filed a proof of loss
Before the lawsuit.
before the lawsuit.
Keep going.
They asked for $71,000, and that included
And?
a new roof.
Well, keep going.
And
And they said nothing about that an appraisal had been done? They didn't seek an appraisal? What were they asking for? Just the 71,000?
well, I cannot recall off the top of my head whether it was First Home or whether it was the claimant who did the original appraisal, or who
Well, the
asked for the original appraisal.
This opinion says that they submitted their claim, their second claim. It was a detailed sworn statement and proof of loss form, so presumably that's in our record, for $71,000, exceeding the deductible. They rejected it and they invoked the appraisal clause. And then at that time, he submitted a letter saying it was the roof tile was no longer in stock. So again, the question is, what happened between 2000, to me, but it
But
looks
that
like...
would be determined in appraisal, wouldn't it?
It would absolutely have been
But
determined
they
in
didn't
appraisal.
get an access to an appraisal here.
I'm not sure I'm following the court.
No, at the time, Justice Barriente is saying if they had discovered that there's something, we still have a dispute, and they asked that it be submitted to appraisal, if it's an unrelated damage, that would be determined during the appraisal process,
Yes.
whether it is or is not.
Yes.
But they never got to that point in this case.
No, they got to, there was an appraisal.
Yes.
There was an appraiser by Mr. Noah, the insurer's appraiser, and a neutral appraiser. They each evaluated...
I don't know whether the issue of causation came
That's
up.
where it would come up, though, isn't it?
I would, yes, absolutely, but we can't tell from this record, and as you know, FIGA didn't come into this case until after there was a lawsuit, so there's just a lot that we don't even know.
But I think it goes back to this. It's the appraisal stated it didn't appraise any allowance for the effects of law and ordinance. It said that. Now, the petitioner interprets that as meaning that when law and order, they didn't consider it at all. I go back to my question to the petitioner. They didn't need to consider it because they appraised it as only requiring 3% of the total 3,200 square foot roof, correct?
Correct.
So nothing about, if that was accurate, that amount, nothing would bring up an ordinance that would require them to replace the whole roof.
Correct, and you know, that's really the big distinction between this case and Joss Folk. In Joss Folk, the insured's appraiser said, hey, wait a second, you know, we're looking for a whole new roof, and we can't, you know, we have this ordinance and law issue, et cetera, and after he raised that objection, the appraisal award was changed a little bit, but for a second time, they said, we're not appraising ordinance and law.
Okay, so
there
can I
you
ask
have.
you a question, which is a friendly question, which I don't usually ask, which is, they distinguished Joss. Do you argue that this is a case that we shouldn't have taken because it's distinguishable?
Well, yes, I did make that argument in briefs on jurisdiction
Do
and
you still
again.
believe that that's the correct legal position, that we don't have jurisdiction?
I don't believe that the court has jurisdiction because I don't believe that this case is express in direct conflict with either Joss Folk or Sabalo, which has absolutely nothing to do with particular issues. I agree that Joss Folk is factually similar, but there are some major distinctions there.
What's the distinction?
Well, the first one being that in Joss Folk, the insurance company didn't actually raise this whole, hey, 25% would require a roof, and the appraisal award fell well below that. They didn't ever make that argument.
Well, they did on appeal.
Well,
I mean, because the opinion says that we reject this argument because it wasn't made to the trial court.
But isn't it the case that even though they made that argument on appeal, the district court, for some reason, said they wouldn't consider it because it had not been made below?
that's correct. It hadn't been
And
made
that's
below.
really the basis for the distinction. They just did, the district court did not consider that argument, which is central to this case.
Right. I mean, that is the be and end all of this court's alleged jurisdiction here, is that these two cases are indistinguishable, and they clearly are not. Bottom line is, and this is what the third district really raised at oral argument, and which is implicit in the opinion, where there's no evidence in this case that the dispute involving the extent of roof damage was not appraised. The assumption is always that it's not just the number, but the extent of a loss that is appraised. And if the appraisal is to have any teeth, it's got to be sacrosanct. And while in Joss Folk there at least was some kind of evidence that the insured's appraiser tried to clarify and say, well, you're not, of course, dealing with ordinance and law because you don't have that ability right now. Here we have nothing. We have nothing except that a month after the appraisal award was paid, they miraculously find a roofer who can't do this work unless he does the entire roof.
Well, you would agree, if it was 30%,
correct.
They wouldn't, under the ordinance, they wouldn't have a choice.
Absolutely, and the roofer never asked for a permit of less than 30%, knowing, presumably, that you have to have the entire roof. And I just don't think, first of all, I don't think that this court has jurisdiction, but if it does, I certainly think the third district's opinion in this case should be the one that this court approves over Joss Folk.
If the insured believed that 30% of the roof had to be replaced to effectuate the damage caused by the covered peril, when should they have presented that information? Would it have been to the to the umpire?
Yes, absolutely, absolutely, and it almost sounds, by virtue of Mr. Pyle's affidavit, which was filed, that he did, that he never agreed, he didn't sign off on the appraisal award.
What it sounds like is he approached it differently and said that because we can't match the tiles, you have to replace the whole roof, and instead the umpire determined that you could match the tiles by some coating that goes on the entire roof underneath. You don't have to replace the whole roof in order to match the tiles.
Yes, and there was a, said 4,000 something award for Hydrosheen in order to match the tiles. Also, the roofer's affidavit didn't say never, it said it's going to be difficult for us to find matching tiles, and the color is going to be a problem. And that, again, must have come up during the appraisal, otherwise there wouldn't be an award for a color match, Hydrosheen, and it was there. So I think under the specific facts of this case, that this shows the wisdom of there being an appraisal system and the importance of it being sacrosanct. There's nothing in here, and I know, Justice Lewis, you were concerned about things you find out afterwards. Certainly if this was something that could not have and was not determined before the fact, or couldn't have been discovered before the fact. There'd be some evidence of that here. We don't have any evidence of that here, and I made that point in our brief. This is not one of those situations where you couldn't have discovered a problem, and only when you do could you have brought it to the insurance company's attention. As far as we know, there's been no change in the circumstances and nothing to warrant having a second appraisal or reopening an appraisal.
Wait a minute, I was under the impression that before, in your response to Justice Periente, you said they did have a second appraisal. They did not. It was one appraisal that was done before all this broke loose, and then they file a lawsuit asking for an appraisal. That's the way I understand the procedural posture of this case.
Now, actually, there was one back in 2005.
Right.
And that appraisal amounted
But
to...
not since they filed the current legal action.
No. There was
A second
appraisal in 2010, I believe. And that is the appraisal that we've been talking about
Okay.
in this lawsuit.
All right.
If there are no further questions, I thank the court for its attention.
With all due respect, there was only one appraisal in this matter. There was a claim that was made in 2005. That was not appraised. They came with an underpayment, and it was their reason that there was a delay for the second claim to come in. There was no two appraisals here. There was one appraisal, and that was done in accordance with what we see here in the record. So I'm not sure.
I have a question about.
I'm concerned about that.
I have a question about what we discussed regarding the Gale Claim Services documentation that's attached to the affidavit.
Yes.
The 1,200 number.
Yes.
Now, if I understood you correctly, you were suggesting that that indicated 1,200 feet of underlayment. Was that what you said?
Yes.
Okay, I'm having trouble following that. I heard what you said, and now, but I'm looking at this, and it says roofing repair underlayment. Quantity, 1.0 each, EA, I assume that means each, and then unit cost, 1,200. It doesn't, it looks like to me that's an aggregate amount that they figured for the underlayment without, it's not related to square feet, and I would infer that from the fact that right below that, it says HydroRush, I can't pronounce it.
I know, it's okay.
Okay,
Hydro
you know what I'm talking about.
Yes.
Roof to obtain color match. And there, it says 3,488 SF. That would be square feet. So if they're talking about square feet over there, then it wouldn't make sense to be talking about square feet under the unit cost anyway.
Yes,
So
yes.
I'm having trouble following your suggestion that that is 1,200 square feet.
I'm glad you brought that up because I've never seen where they haven't put square feet in on these first two items. So I was concerned about that because naturally it would flow that that has to be 1,200 square feet because that's how these are done. But separately.
Well, that's not what it says though.
But the fact of the matter is that, yes, it doesn't say that, and I'm concerned that they didn't put that in initially.
Well, it's like it's an aggregate cost that they somehow he figured in the same way that he figured an aggregate cost for the taxes, insurance, and permits and fees. Okay, that's 1.00 each. And for the hauling debris, they do an aggregate cost on that. He's done an aggregate cost on the roofing repair. You cannot, I can see no way looking at this in context that you can infer from that it's 1,200 square feet,
Well,
which is what you were suggesting.
If you see the hydro sheen, it's over the whole roof, which shows that actually these tiles were spread out over the whole roof, and it was not just in one area. Okay.
Well, I don't think that's been disputed.
Okay, and then I want to bring. Well, I think that the 1,200. It's 1,200 square feet of underlayment is plywood. I believe.
Where does it say that?
That's in the roofer's affidavit. If you look at our roofer's affidavit, he states that that was the underlayment that he had to put in, and that matches what is on the estimate of Mr. Gale. So that buttresses actually the argument that and addresses exactly what you're asking, Your Honor, about
But
that.
it's a unit cost with 1,200. I mean,
But the affidavit of the roofer.
I know we're over
connects to-
time.
I do want to
But
make.
I want to ask one question.
And I want to make just a couple
Well,
points.
that's up to the chief, I think, but,
I am the boss. Go ahead and ask
But-
your question.
can you, very briefly explain how we have jurisdiction when the issue you're asking us to decide was expressly not addressed in the Fort DCA opinion?
The issue of the jurisdiction is that under the facts of this case, in our appraiser's affidavit, he states, it's on record 44, indeed, appraisal of ordinance and law coverage was left open for consideration at a later date if it became necessary. It became necessary, and therefore, just as in Joe's Folk, they requested it. He requested it before the roof was done. They said no, and he said, okay, I'm going to go ahead and I'll go ahead and just do the whole roof, and then he would file the lawsuit afterwards. The fact of the matter is,
How's it express and direct conflict when the Fort DCA says we're not considering that issue?
Because they allowed appraisal in Just Folk, and they did not allow the appraisal of ordinance and law in this matter when it should have been allowed because of the nature of the facts and the circumstances of the case.
Justice Queens, did you have a question?
And one more point. There was an issue about the delay. My client timely noticed this right after the storm, and the fact that they didn't adjust it properly should not be borne by my client. That should not be his fault. So we respectfully request that the decision of the Third District be reversed, and at a minimum, given the issues of fact that the court has pointed out, that it be sent back down for further proceedings.
Thank you for your arguments.
Thank you.
We're in recess for 10 minutes.